Mr.
Pavlinic. Good morning, ladies and gentlemen. The indictments, the criminal information in this case was filed in March of 2005. And this case has been a part of our lives for 5.5 years. And as Mr. McDowell and I started wading through the transcripts of the first trial and the second trial and the DVD tapes and the pleadings and the evidence and the exhibits and reading the cases in Cooksey, we sort of, at the time there, became overwhelmed by what was happening in this litigation. But when we took a step back and looked at the issues in the case, two very clear and distinct principles came shining through. The first one is that Mr. Crispino was denied a unanimous jury verdict. And the second principle was that the confusion that pertained to the indictments, the time frames of the indictments, denied him a fair trial. And why is that? That happened because this whole procedure is as a result of the state's determination as to how it intended to proceed. In this particular instance, it's the state and the state alone that drives the bus. The state determined the charges. The state determined the time frame set forth in the indictment. And the state decided during the presentation of its proof during the second trial to introduce proof that varied from the testimony of the first trial and varied from the time frames set forth in the various counts of the information.
Well, assume for a second, hypothesize that the jury sends a note out to the circuit court, and they say, we are persuaded beyond a reasonable doubt that the defendant committed this crime, but we are not persuaded beyond a reasonable doubt that he committed it between July of 1999 and July of 2001. We're persuaded beyond a reasonable doubt that he committed this crime on July 4th, 2003. What do we do? What would the court respond to the jury under those circumstances? You must acquit him because they've proven he committed it while the children were, I guess, 5 and 7 at that point in time, but the state failed to prove that this crime occurred within that time frame.
Okay. It goes back to the principle of law that the Court of Appeals quoted. It said that a time frame is not essential in every aspect of a criminal information as long as the events took place before the indictment within the statute of limitations. But then it has the qualifying language within reasonable limits. And that issue that you raised, Judge Murphy, is important because it impacts the two different crimes differently. How that impacts the child abuse statute is much different as to how it impacts the second-degree and third-degree sexual offense.
There may be situations in which the date of the offense is vitally important because of the age of the children referred to in the statute. But here, we're talking about something that occurred when the defendant was in his early 20s, and the children were 7 and 9, or 4 and 6. So it isn't a situation in which the defense is entitled to say, we need a jury determination of when this occurred, because it may not be a crime if it occurred when we say it occurred.
But the reason it was important is because in the child abuse statute, custody is an essential element. And in order for Mr. Crispino to have been convicted of child abuse, they had to prove that he had custody.
Yeah.
All right. And then, but the testimony about when he could have had custody was unrefuted. It had to have been
post. You're saying that the circuit court should have granted a motion for judgment of acquittal in this case because there was no question about the fact that there was no custodial relationship when the crimes occurred?
No. We're saying that we should have had the opportunity, Mr. McDowell should have had the opportunity to fairly comment on the evidence and say to the court, Camberly says that this abuse allegedly took place while he was babysitting. And there's unrefuted testimony that the babysitting didn't start until after November 2001 at the earliest. And we were not allowed to comment in closing argument and argue to the jury that how could you find custody if she's testifying that these things happened when she was 5 and the custody couldn't have happened until over a year later.
Well,
that was
it's
the point.
one thing to say the court made a mistake in precluding defense argument, but that isn't what I understand the issue to be here this morning.
Well, we wanted the jury instruction, the second issue that we reframed, the jury instruction, to say that they had to find that the abuse took place within the time frame committed in the indictment, in the information.
Yeah.
And that was important to us because of the proof, rather the evidence that the state adduced at trial when Camberly said that it happened when he was babysitting for us. And he couldn't have been babysitting in the time frame that was alleged in the criminal information or by their uncontradicted testimony.
Why couldn't he?
Well, because the
jury is entitled to accept all, part, or none of the testimony of any witness and draw reasonable inferences and so forth.
But there was no testimony to the contrary. They would have had to draw on the inference that the babysitting took place post-November 2001. There was no evidence to the contrary. Both girls said that.
Well, we're back to my question. Why wasn't your client entitled to a judgment of acquittal rather than a jury instruction on the point? If that's the only evidence, if no reasonable person could conclude that it happened the way the kids said it happened, why isn't this a motion for judgment of acquittal issue rather than a jury instruction issue?
Well, because the element of custody was technically satisfied when she said he was babysitting. How would we argue a motion for judgment of acquittal when the state's evidence produces the testimony of the element? They established the custody through the babysitting. So we would have not been able to argue a motion for judgment of acquittal. The trial judge would have said, well, Mr. Pavlinic, look at the evidence in the light most favorable to the state. How can I grant you a judgment of acquittal when the evidence says that he was babysitting?
Well, you know, the problem with babysitting is it's a kind of a funny term. It may mean there's a formal contract and the kid is getting, $50 to sit there and babysit for the night. It may mean the people are going to run an errand and go to the grocery store, and the kid is babysitting for 25 minutes while they're down shopping at the grocery store. That would be custody, wouldn't it?
It would.
Okay.
So that would prevent the entry of a judgment of acquittal, technically.
I'm totally confused now. I thought that you said that there was no way that anyone could have found that he was in custody of these children at the times that the state proved, not what was in the indictment, but the state proved that the child abuse took place.
Okay. Yes.
Well, then, let's stay with that. Mm-hmm. If that's a yes, then what Judge Murphy's saying is that the judge would have had to grant a judgment of acquittal. It wasn't a jury issue, because then the custodial element could not have been met and was not met by the state.
Okay. Well,
it was not a jury issue.
If we erred by not raising a motion for judgment of acquittal stating that the custody had not been satisfied, if we made that mistake, I don't see that mistake only because of the proof where the girl said that he was babysitting. And the court concluded that the time frame wasn't an essential element of the charge. The trial court concluded, Judge Martin concluded, it doesn't matter. The time frame doesn't matter. So when the trial court concluded that the time frame didn't matter, we were not able to argue that the time frame did matter and place her credibility into question because of the unrefuted testimony as to whether or not there was babysitting. If the court had concluded, well, yes, you gentlemen are right, the time frame does matter, And the only time that the girl's saying he testifies is after Mrs. Crispino leaves, then yes, we would have been entitled to a motion for judgment of acquittal. We would have been entitled.
Well,
But
if the time frame matters, it only matters as a matter of law, not as a matter of fact.
yes.
So that's the issue that I understand Judge Murphy's raising. Then it's not necessarily a jury instruction, it's a but in any event, I understand what your argument is.
You did?
I got what you're saying.
All right. The lack of, just let me just capsulize it so that I make sure that I've, for my own benefit, the fundamental fairness that stemmed from not being able to tie the proof to the time frame set out in the criminal information prejudiced at trial because we couldn't fairly comment on the evidence. We couldn't point out to the ladies and gentlemen of the jury that the girls were saying one thing and the state's proof produced something else. That was the argument on the child custody issue vis-a-vis the custody component. The unanimous jury verdict, I think that issue is so clear. It just shines right through. And we looked at the verbiage in Cooksey about where the state has alleged through its proof, not through its pleading, through its proof, 2 acts of cunnilingus, 2 acts of kissing. And there's only 1 count in 1 time frame, in 1 place to cover those acts. We would be entitled, according to the language in Cooksey, for the jury to determine which one of these things took place or that they all took place during the time frame set forth in the information. That is our reading of Cooksey. That's our reading of the interpretation of those cases. And why that's important is because the whole principle of jurisprudence in a criminal case is that the jury agrees on an act and they enter a verdict, and there's a punishment, a sentence, attached to what Mr. Crispino allegedly had done.
Could French kissing and cunnilingus individually be found to be the basis for child abuse?
Well, cunnilingus clearly is a basis for child abuse. There's,
could French kissing
okay, that, in,
child?
in anticipation of that question, we've discussed that. It's not delineated in the statute. The verbiage of the statute says sexual exploitation or molestation.
But in terms of a reasonable jury, could a reasonable jury construe French kissing to be a sexual act?
Not a sexual act, but potentially sexual contact.
Sexual conduct.
Yes. You know, I have to answer that this way, Judge Battaglia. I think that if the legislature wanted to include kissing in a statute that delineates such horrendous acts, rape, sexual events in the first and second degree, sodomy, specific acts of sexual acts, as that term is used in the definition section of the criminal law, I think that kissing would have been included.
I'm not asking about kissing. I'm
French
asking
kissing.
about French kissing. And that's different, obviously.
Mm-hmm.
Rather than get into a definition here, I presume that everyone knows the distinction between French kissing and kissing. Could it be construed to be in any way with a child of, 4 and 6, 5 and 7, to be construed? Could a reasonable jury construe it to be?
I would have to say yes. It would be absurd for me to say that French kissing could not be considered in any reasonable mind an exploitation of a child. Why would an adult be French kissing a child in a context other than in a way that would be improper? But that's
why was the Court of Special Appeals wrong, though, in using the analogy, I guess, of the Supreme Court case involving a robbery, where the jury has to be convinced beyond a reasonable doubt that the defendant